Welcome. My name is Paolo Annino, and I teach at Florida State University College of Law. I'm honored to be here today, and I want to thank Alan Abramowitz and Thomasina Moore with the State Guardian Litem program for inviting me. As I mentioned in segment one, I'm very excited to be here because of the great opportunity. The legislature and the governor, thank you both, have provided roughly $16 million extra funding, which is going to be leveraged with federal money to be able to remove 2,000 folks. And most are going to be children, and most are going to be DCF children from the DD wait list. And that's going to provide them incredible services. And what needs to happen next is folks out there in the community with the GAL program and their volunteers and need to, as they say in Commonwealth nations, pull up your socks and let's just move forward and get these kids off the wait list and getting the habilitation services they need. Okay, so now we're talking about in segment two, how to become eligible for a DD waiver. So segment one, we explained it. Well, the first thing to become eligible is to apply, right? Application. So the first stage is the application stage. Application stage. So that's the first stage. The application to whom? It's to the agency for persons with disabilities. Agency for persons with disabilities, the state agency that operates our DD waiver. That operates our DD waiver. So you apply to the Agency for Persons with Disabilities. Agency for Persons with Disabilities has divvied up the state into these large regions. So here in Tallahassee, the local office is right here in Tallahassee for a good part of our panhandle. Okay? So very easy, just go online, Google APD regions, and you'll see what region you're in, and they'll have the address of the local office. And so you can pick up an application at the local office, or you can pick up an application for the DD waiver online. And what we're going to do today is add a group of documents, and one of the documents is going to be the APD application. So you'll have it also through this video. Okay, so the first stage is simply filling out this application, which, by the way, compared to a Social Security application or many others, is pretty straightforward. It's a very straightforward application. And at the end of the application, it says, please attach documentation that establishes that you qualify for the developmental disability waiver. And when I go around the state and I talk to folks, and two things I learned. One is that the majority of folks who apply at the application stage get denied. And two, that the reason they get denied is they fail to do what's required. And that is they fail to submit with their application all the key documentation that establishes that this child in specific has a developmental disability. I know often community-based service workers and GALs and DCF workers, everyone's in a hurry, right? Everyone's really busy. And so they do these applications and they just submit them and they get denied and they just throw their hands up. Well, with all due respect, that's the wrong way of doing it. Really, the application is a very serious process. It should not be submitted if you don't have all the documentation you need. So what do you need? I gave a talk on video here on special education, and I said evaluations, evaluations, evaluations. Same thing here, absolutely the same. You need evaluations, evaluations, evaluations to do what? To establish that this child has a developmental disability. Again, to establish that this child has a developmental disability. Now, where are you going to get those evaluations? First thing, it takes time. There's no I mean, I know people are in a hurry and they want to rush things. It takes time to locate the key documentation and records you need, the key evaluations you need to establish a developmental disability. So what documentation, what evaluations am I talking about? Well, the first one I think is very important. Now, most of these children, because they do have developmental disabilities, are going to be in special education. And as I said, I did a video recently for the Guardian Ad Litem program on special education. And one of the things, in order to get on special education, we learned was you need evaluations. So first thing is going to be the IDEA, Individual Disability Education Act. That's the federal act that deals with special education. And it's going to be, so you're going to have an evaluation to become eligible for special education. So you'll need an evaluation. So that's a key document. You want the special education evaluation. Now, what occurs with special education evaluations? You have your initial evaluation that makes you that gets you into the special education program, but every 3 years they redo it and you have a full evaluation. So what do I want? I want all the education evaluations that were done on this child. So I want the initial evaluation and I want the 3-year evaluations. How do you get those evaluations? It takes time. You have to contact the school. You have to have consent forms. And from the school records, you go out the evaluations, the school evaluations. What else do I want from the school? What other documentation do I need from the school in order to establish that this child has a developmental disability? Well, another key document that I use over and over again, in the previous video we discussed it a lot, is called the IEP, Individual Education Plan, IEP. I want the last IEP. Sometimes, if I can, I want all the IEPs. So I want to go out from this stack of school records, all the school evaluations, all the IEPs. Because the IEP will decide what's the primary, will indicate what the primary disability is for this child. It will indicate that. So it'll be helpful in order to establish our argument that the child does meet the qualifications under Chapter 393, disability. So the first group of documents I want are the education documents. 2. What else? Well, another source of evaluations is the foster care system itself. The foster care system, these kids, many of them are evaluated. So that's a great source, your own records from the foster care system that were done for this child. So foster care evaluations. Those are helpful. What other type of evaluations? Many of these children who have developmental disabilities are receiving Social Security benefits. In specific, what they're receiving is SSI, Supplemental Security Income, SSI, Supplemental Security Income. Well, in order to receive SSI, what are you required to have? Evaluations. So those evaluations that were done for Social Security, those will also be very helpful. What else? A variety of other places. The delinquency, say some of our kids that we represent who are developmentally delayed have gotten in trouble with the law. And when a kid who has a developmental disability gets in trouble with the law, a public defender usually, one of the first things they do is file a motion for competency. So there's an evaluation of competency. That would be great. Those are great evaluations. So also evaluations from the juvenile justice system. specific, those evaluations dealing with competency. Again, that's another source of evaluations. Now, these are all four that I mentioned here, special education records, evaluations and IEPs, foster care evaluations, social security evaluations, juvenile justice evaluations, are evaluations that already exist. And what your job is to collect those documentation. But then there's a whole nother way of obtaining records. And that's not collecting, that is by constructing. That means sending the child to a psychologist or to a doctor to be evaluated for a developmental disability. And so I can talk about different guardian ad litem programs in the state have funded developmental disability evaluations. That's one way of getting an evaluation. Different community-based agencies in the state of Florida have also funded evaluations for developmental disabilities. The foster care court can be asked to do an evaluation, an evaluation on developmental disability. So we have three different sources then, at least, of new evaluations that can be constructed to determine whether or not this child has a developmental disability or not. Now, I mean, in my own office here, center, we rely on some very responsible psychologists. And when our psychologist comes back and says, this child does not have a developmental disability, then the answer is, that's the answer. And we don't pursue it any further. And we look at other avenues to get the services this child needs, like EPSDT, as we talked about in the last segment. Okay, so either you collect the documents or you actually, what I call construct, meaning you hire an expert to evaluate for DD, for developmental disability. Those are the two ways to get the documents. And both ways will take time. It might take a couple of months even to do both of those record gathering. So, but my recommendation is don't bother filing an application if you don't have the documentation required up front. So you submit your documentation to the local APD office. If the child is over 6 years old, then I believe they have roughly 60 days to make a decision. So you submit the filled out application, you attach all of your documentation. What I always do, I'm big on doing a tab and also an index, so I index all the documentation I have and I tab it also. And I submit, so make it easy for the local APD office to make a determination of whether or not this child qualifies under Florida Statute 393 in having a developmental disability. Okay, so you do that, they have 60 days, and what happens? The agency denies you. What's your remedy at that point? What's your remedy? Well, your remedy is an administrative hearing. And this administrative hearing is de novo. De novo. Well, that means, as they say in Latin, tabula rasa, a clear table. It starts anew. There's no preference or deference given to the agency. It's de novo. So it's an administrative hearing. The first thing that's really important, if you do lose and get denied at the application stage, is you file your application within 30 days. Within 30 days. So you file your application. Application is really no big deal. It's a one-page form. You simply state that you disagree with the decision, and you submit it to the local APD office. Or if you don't want to use your form, you can simply have a letter sent to the APD office saying that you're requesting an appeal. Now, anytime I communicate with APD or any really state agency, I always send it certified mail, return receipt requested, because I want to establish and prove that they actually received my request. And it has to be done within 30 days. Okay, so you file your appeal, you have a right to a de novo administrative hearing. What's the burden of proof? It's a preponderance of evidence. Preponderance of evidence, that means as long as you have evidence more than 50%, preponderance of evidence. Who has the burden of proof? The person, in general, the petitioner, and you're the petitioner, because you're petitioning the administrative body to overturn the decision made by the Agency for a Person with Disabilities. So you file your notice of appeal. The next step then is a notice of appearance. That's fairly standard. If you do not actually file, especially the notice of appeal, but your client did, or the community-based agency did, or the guardian ad litem did, it's very important to file a one-page traditional notice of appearance and the certificate of service. At this point, you probably don't know what attorney that is with Agency for a Person with Disabilities handling the case, so I just sent it to the general counsel office, a notice of appearance. If you're not an attorney, you can, in these type of hearings, you can represent someone, a person with developmental disabilities, on this type of appeal if you're not an attorney, and that is through something called qualified representative. Qualified representative, it's a motion for qualified representative. Where do you learn about how to do this? It's, you look at the rules, and there's special rules dealing with these type of administrative hearings. First thing I want to get across, that this is not, repeat, not a DOA hearing. DOA is Department of Administrative Hearings. This is not a DOA hearing. That's our traditional administrative hearings. This is, it's called a fair hearing. These are fair hearings. Fair hearings. Sometimes people get confused and they think this is a DOA, they're going to a DOA hearing. No, that's not correct. This is a fair hearing, and therefore it's a different set of rules. The rules are in Florida Administrative Code, and we'll have those for you at the end of the video, Florida Administrative Code. And who conducts the fair hearings? The fair hearings are under the umbrella of the Department of Children and Family Services. So these are not DOA hearings, these are hearing officers under the Department of Children and Family Services. These are the same hearing officers who do food stamp hearings for the Department of Children and Family Services. So these are fair hearings, and there's a set of rules under the Florida Administrative Code dealing with the procedure at a fair hearing. Okay, so you need to be aware of that set of rules. These hearings are telephonic, and years ago I really objected to the fact that they're telephonic. I thought that would deny due process, but I've come around. We've done a number of these fair hearings, and there are some advantages of telephonic. You don't have to worry about your ties appropriately pulled up, or you didn't shave that morning, and it's a little more relaxed insofar as your table is concerned. You don't have to make sure your table is nice and clean or anything like that, because it's telephonic. However, there's a whole other side to it. Telephonic requires extra preparation. It requires extra preparation than an in-person hearing, meaning that you have to have your exhibit notebooks with your evidence to your witness ahead of time. And you have to have your exhibit notebook with your exhibits to the judge ahead of time. So you just can't, at the hearing itself, submit it. You need to have it ahead of time so they can follow your argument. Again, anytime I submit anything to any agency, I said earlier, so my exhibit notebook, I did certified mail return receipt requested. So it has to be done ahead of time. So this is not a type of practice that you can just do it by the wing of your shoes, so to speak. You do it, you have to plan it out ahead of time, because it's going to take some time for these exhibit notebooks to go to the other side, the APD, and to go to the hearing officer. There is another big advantage is most of my experts are around the state. They're in Miami or they're in Orlando. the experts I use. So with a telephonic, it's very easy for the experts to participate in the hearing by just being on the phone. Okay, so just to summarize a couple of points here, it's the fair hearing rules that apply. This is not a DOA hearing. These are telephonic hearings that is by preponderance of evidence. And you have a right to an opening statement. And I know many times in administrative hearings, folks waive the opening statement. I think that's a mistake, especially for this type of hearing. I think it's important that an advocate frames the issue. What exactly is the issue? What is the dispute? What is the dispute that is between your client and the Agency for Disabilities? What exactly are you disagreeing on? Now, and I wanted to mention, how do you know what that dispute is? Well, when you get the denial notice from the Agency for Persons with Disabilities, it will give you some information, some inclination what the dispute is, but many times the notice will be very generic. It will simply say, your client does not meet the requirements of Florida Statute 393. What specific requirement? What is my client missing? All those types of things, many times you don't receive, you don't pick up from the denial notice. So that's why, in addition to doing a notice of appearance up front, it's really important that you do discovery. So as soon as you file your appeal, you should file your request for production of documents. That's the key discovery tool that you need to file. Because that tool then will give you the key records, and from those records, you're going to be able to determine exactly the reason why your client was denied. Not this generic, not complying with 393, not fitting under 393. You're going to know what specific reason. An example would be is, we're going to talk about, in the next segment, we're going to talk about some of the details of how to get a Medicaid waiver. But one of the things for a developmental disability, let's say intellectual disabilities, is you have to have an IQ less than 70 or less. And maybe by doing the discovery, you'll discover that they're saying, oh, we found an evaluation that you have an IQ of 72. So that's what the grounds are going to be the disagreement. You have an evaluation that says 65, they have an evaluation that says 72. So your goal in the opening statement is to really be real clear to the hearing officer what the disagreement is, what the conflict is between the petitioner and the Agency for Persons with Disabilities. And the way you find that out is by doing discovery, request for production of documents. By the way, you really want every document, but the specific documents you want are the evaluations that the agency is relying on in their denial of the Medicaid waiver. I also do interrogatories. I keep those really short. Interrogatories, I just want to know who their expert is, because we know they're going to have an expert testifying. So I want to know their expert, and I want also the curriculum vitae of their expert. Okay, so I said that's important to do an opening statement. How does the hearing actually work? Well, usually, not all cases, but usually both sides will have roughly 2 witnesses. So if you're the petitioner, you're going to have an expert witness. Now, if you can't afford an expert witness, then don't go to the hearing. That's simply you're not going to win. The only way to win these administrative hearings is an expert witness. Why? Because Agency for Persons with Disabilities has an expert witness, and that expert witness will say that your client is not eligible. So if you go into a hearing without an expert witness, there's an imbalance. And the hearing officer will always fine for the agency if you don't have an expert. So you need to have an expert. Again, how do you pay for the expert, right? That's always an issue. Again, the community-based agencies have been very generous. The guardian ad litem programs have been very, very generous sources of funding for expert witnesses. But you do need an expert witness. And what type of expert witness you need depends on the developmental disability you're trying to establish. If it's a intellectual disability or autism, for example, but let's say intellectual disability, then the primary expert is a clinical psychologist who can do testing to determine whether or not your client has a developmental disability. So you need an expert. I want to talk about the direct examination of the expert. The direct examination of the expert really is two stages. One stage is the affirmative story. So your expert will do evaluations, will review all the evaluations you collected, and will discuss in detail. So there's nothing fast here. We'll discuss in detail all the past evaluations you're relying on, and we'll discuss in detail his or her own evaluation of the child. And we'll tell an affirmative story about the child being developmentally delayed. The mistake I see that happens is attorneys are good in collecting the documents, constructing documents, good in practicing with their client in telling their affirmative story. The mistake they make is that's not good enough. Your expert has to also rebut. Your expert has to rebut the story that APD tells, has to show that the APD's expert is wrong, that their evaluation is wrong, and explain in scientific language why APD's expert is wrong. You're not a clinical psychologist, so you really need to rely on your expert to explain the weaknesses in APD's case. And the way I do it, even though I use the word rebuttal, I don't use the person as a rebuttal witness. In a direct examination, first half I usually do affirmative, and the second half is I have my expert talk about the APD's evaluations and why they either did those evaluations incorrectly, they used the wrong tool. That's very common. So let's say IQ test. They used the IQ test that wasn't recognized by our state regulations. That's common. Or they used IQ test like an iTony, which is a non-verbal IQ test on a kid that's verbal. You know, so there's a number of times, a number of things that your expert can pick out of why that the APD evaluation is incorrect. Or the APD relied on subtests rather than the full score, or the opposite. Again, you're looking for the truth, so you really want your expert to evaluate it, and ahead of time the expert says they're correct and they're correct. And then you need to find another Medicaid service that will provide the services that your client needs. Okay? So, but again, the key to win these hearings is expert, 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 and they win because you have collected and constructed all the records that your expert's going to rely on. I know there was a hearing not too long ago where the advocate had the records but no expert. And it was like, again, you can't win if the other side has an expert and you don't have an expert. That's simple. That's a simple fact. So first witness is going to be, or the most important witness is your expert witness. The second witness is what I call a fact witness. So you're going to have expert witness and you're going to have a fact witness. Okay, expert witness and a fact witness. Your fact witness is going to be someone who knows the child. It could be a DCF caseworker, it could be a community-based services caseworker, it can be the foster parent, it can be anyone that can tell the story of the child, but tell the story what he or she, it's a fact witness, what he or she experiences with the child. So, for example, a fact witness can say, well, I went to Baskin Robbins for ice cream, I gave the child $1, and the child could not make change, could not determine what the proper amount was for the ice cream. Oh, or the foster parent can say, in the morning I have to ask little Josie, to take a shower. And then when she's in the shower, I have to tell Josie to use the shampoo. And then after she uses the shampoo, I have to tell Josie to wash off the shampoo. Again, your fact witness is someone who's going to be able to tell the day-to-day, day in the life of the child through his or her own experiences with the child. Okay, so the fact witness is used to what I call humanize the child. It's a way to introduce the child to the administrative law judge. Sometimes I have the children testify, but most of the times I don't in these type of cases. Because really these are scientific cases. These are cases really depending on medical diagnosis and scientific evaluations. But it's important to have a fact witness to talk about the real life, not just science, but real life, what happens with interactions with the child. Also, if we're talking about intellectual disability, and we're going to talk about that in the next segment, there's two prongs. One is having an IQ less than 70 or 70 or less. There's also, the second prong is having deficits in adaptive behavior. Well, that fact witness will be a key witness to testify about our anecdotal or his anecdotal experiences with the child showing deficits in adaptive behavior. So let's say, for example, the child just runs in the middle of the street. So safety concerns. Those are examples that the fact witness can testify to. So you need to have two witnesses, expert witness and a fact witness, the expert being the most important. So you go to hearing, is there a closing argument? Generally in these type of hearings, there is no closing argument. There's no closing argument. Instead, like many administrative hearings, what happens is, what occurs is, instead of a closing argument, you do a proposed recommended order. So both parties, APD and the petitioner, do a proposed recommended order. Now, what is a proposed recommended order? It's like, the way I describe it is, it's like you're the judge and you just won the case, right? And so you write the order as if you won the case. So it has two parts, conclusions of fact and conclusions of law, conclusions of fact and conclusions of law. And so you write the facts, you don't change the facts, you can't do that, but you write them in a way that benefits, that emphasizes your case, and you select them in a way that emphasizes your case. And same thing with the conclusions of law. So you write as if you won the case, and that is a proposed recommended order, and APD will do the same. They will go out and select the facts that benefit their case, and they will go out and select the different legal provisions that benefit their case. So the judge has both proposed recommended orders. Let me just step back for 1 minute. you know, sometimes there's an issue of transcript, no transcript. How do you do a proposed recommended order without a transcript? You know, look, truthfully, most folks here, we don't have the money for transcripts. You know, sometimes we are able to get transcripts as public records. In many of these hearings, we don't request transcripts just because of a funding issue. But if the agency receives a transcript, then you can also then, through a public record, obtain that transcript for little or no charge. So usually there's no transcript, so how do you do it? How do you do a proposed recommended order like statement of facts without a transcript? You just, first thing I always recommend at these hearings, because there's always an issue with transcript, that you have someone who will sit down with you in the room taking detailed notes. So you should not be the note taker. You should have one of your colleagues sit there and take detailed notes about what each witness says. So not interpret it or not give it any kind of slant to it, but just take detailed notes about what each witness said. So then when you're doing your proposed recommended order, the section dealing with facts, you would do your, and these are numbered paragraphs, by the way. At the end of your statement, your factual statement, you would put C, testimony of Jane Smith. Okay? Because you don't have a transcript, so you're going to have to just refer to her entire testimony. But for every paragraph every factual paragraph, you should have a cite to what, either a testimony or an exhibit, that either you submitted into evidence or APD submitted into evidence. After a proposed recommended order, the administrative law judge, and they call them hearing officers, administrative hearing officers, does something called a recommended order. And what a recommended order is, the administrative hearing officer kind of reads both proposed recommended orders and decides yes or no. Does the child have a developmental disability? Yes or no. It's a binary question under Florida Statute Chapter 393. And so the hearing officer will write a recommended order. Sometimes they're like 10 to 15, up to 20 pages sometimes. Again, going over all the facts that establish the child does meet a developmental disability, or all the facts that establish the child does not meet a developmental disability. So there's a recommended order that's issued after a proposed recommended order comes out. And then let's say you lose. What do you do next? Well, then the next thing you need to file is something called exceptions. Exceptions. So you file exceptions to the recommended order. And so you point to different paragraphs and you explain why you think the judge got the facts or the law wrong. After the exceptions are filed, and the other side has opportunity to respond to the exceptions, by the way. They can respond to the exceptions. After the exceptions are filed, then the agency issues a final order. So, proposed recommended order, exceptions, and then the final stage is a final order by the agency head. And the agency head, when they do the final order, as to facts at least, is very rare do they ever not follow the facts as given, because they have to show that there's a lack of substantial evidence supporting that fact. So facts are almost immune to final orders, and when they do tamper with facts, usually that's when an agency gets overturned. Okay? So this is the process, the administrative process. If you lose at this administrative law stage, so the agency order rules against you and finds the child not disabled, then the next step is an appeal to the district courts of appeal. And if I can say, many cases do get overturned at the district court of appeal. One thing I do need to mention, which I just mentioned is just in passing, I mentioned about the exhibit notebook. What I recommend is, back to the exhibit notebook, is once you get your notebook all done and you have an index and you have it tabbed, you submit it early to the attorney with the agency for a person with disability, and I've had very good experiences with the attorneys with the agency with disability, working with them, and see which exhibits that you can stipulate to as admissible into evidence. And many times what will happen is they will stipulate to all our exhibits, and we stipulate to all their exhibits. So, but you need to have that conversation with the attorneys with the agency of a person with disabilities ahead of time, so it'll make it easier, so the judge will know which exhibits are just contested and which are not contested. Okay? So again, that's the process for at the administrative stage. Really, I really don't want you to do the administrative stage. I really want you to win at the application stage. But again, you can't rush that stage. You really have to have all the documentation you need to establish that the child does meet a developmental disability under 393. Now we talked about eligibility. The next thing we're going to talk about in our next segment is dealing with this 20,000 person wait list, and how do you get off the wait list after you've been found eligible. Thank you.